So far we have been considering principles in moral theology, fundamental principles that are presupposed in all moral judgments and applications, purpose in life, human responsibility, about freedom and about knowledge, about moral principles themselves, what they're based on, and then the norms of morality. What's external to us has been any notion of law, and internal, that application that we call conscience. In this segment and for following ones, we move while presupposing those same moral principles, but make particular applications in particular areas of morality. One of them that we read a great deal about today has to do basically with maybe the umbrella term of what we would call medical ethics, and what I'd like to try to present is one or two principles and applications that I hope clarify a number of things that come up in this area. The first one really should be obvious, but we have to state the obvious because the obvious is not always obvious to all our contemporaries. We presuppose in all Catholic medical ethics the principle of what we call the useful dominion over human life. In terms of dominion, some would have it, I suppose, in the age of autonomy, that they have absolute dominion over human life. Had we created ourselves, I suppose that that would be true. But since we believe that human life is a gift we have on trust for a while, and then we go back to God, then strictly speaking, we are not the landlords of our own life. We are merely but tenants. And we always speak of a useful dominion, perhaps a responsible stewardship, some kind of custodial care over human life, including our own. And this will often be the fulcrum and the point of focus when we are considering an operation, an outlay, a procedure. The question we ask is whether or not a particular procedure or operation or treatment is an exercise of useful dominion or responsible stewardship. So when it is something that could involve actually the destruction of our own life or something that is suicidal, in conventional Catholic teaching, we do not consider that as an act of useful dominion, because it's an act of absolute dominion, which would be when you have a watch that no longer works, you might throw it away, or a car that no longer runs, you get rid of it, and we junk other things. But we don't, and we can't apply that to human life. So that in all the other things that follow, we have to presuppose that we're talking about the responsible, trustee, custodial care of human life, and we understand that in a non-suicidal way. That's a little one, but we just put that notion of useful dominion at the beginning. What I'd like to try and outline is a distinction that comes up a great deal, see if we can't define what it is that we're talking about, flesh it out with a few examples, and then make perhaps a few applications. Very often, not only in morality but in medicine, we will hear the terms ordinary and extraordinary means. And that's basically what I would like to spell out here, if we can today, because it's a tremendously important distinction, namely that between an ordinary means and an extraordinary means, and see if we can explain what the Catholic teaching is and what it means. Strictly speaking, it's a very old and well accepted distinction. It was given particular precision by the late Pope Pius XII back on November 24th, 1957. Our Holy Father, Pope Pius, did not invent the distinction, but he did refine it a great deal, so much so that I think I can say honestly that the same distinction is well founded in medicine and in morality and in law as well. For instance, if we were to consult these ethical and religious directives for Catholic health facilities, these are the moral code, if you will, of a Catholic hospital or a Catholic institution. In general, they spell out some very general principles, but then in certain areas they spell out some specifics. And even our distinction about ordinary and extraordinary means will work its way through there, but it won't be spelled out in detail, which is one of the reasons I would like to try and do that in this particular effort. What is it that we mean when we talk about ordinary and extraordinary means? I offer one caution, because what we're talking about basically is their moral understanding, or their moral acceptation, or their moral application. There is a sense in which sometimes people use the term ordinary and extraordinary in relation to medicine, namely in relationship to medical science as it now is, so that everything that is tried and tested, proven, certain, where you know the outcome, vis-a-vis medical science today, some would call all of those things ordinary. What is untested, unproven, insufficiently established, or simply a shot in the dark vis-a-vis medical science, some might call that extraordinary today. We understand that application, and in almost all cases we will agree in the application. But strictly speaking, when we talk about moral theology, we use these terms not in relation to medicine as science as it now stands, but always in relation to an individual patient in his or her here and now concrete circumstances. Okay, and some of those circumstances will not be, strictly speaking, medical, but they will, strictly speaking, have moral relevance. I hope to show that a little bit later. What do we mean in these terms then? Whenever we're talking about an operation, a procedure, a treatment, we try to ask whether this particular operation, procedure, treatment, whatever the modality is, whether it is an ordinary and extraordinary means for a given patient. And how do we calculate that? Well, we ask basically three little questions. The first has to do with benefit. Does this operation, this procedure, this medication, does it offer this particular patient a reasonable hope of benefit? Does it offer some hope of benefit to this patient? The question is not whether it's a benefit to the human race, or it's generally a benefit to other people, but whether it is really a reasonable hope of benefit to this particular person in his or her present illness or distress or what have you. And we use the word hope of benefit, not hope of recovery. Recovery is kind of a promise word. Recovery, you'd have to ask the next question, recover to what? Recover to what I was when I was 18. Well, there are a number of things I now have I can't recover, and some of them I don't want to. But so the first question is, does it offer a reasonable hope of benefit to this particular patient? Secondly, does it involve a serious danger of death? Serious danger of death. For instance, in some cases it will be 50-50. It will be highly problematic, say, that someone could actually get through or come out of an operation. Something that is that skeptical, that iffy, that problematic, whether or not someone would survive, almost by definition would have to call that an extraordinary means. But does it involve a serious danger of death? And then thirdly, we ask about whether the treatment is excessive. Namely, does it involve any excessive pain, excessive hardship, excessive expense, excessive subjective repugnance, or excessive burden? Now, we try to put those together. I'm not suggesting that they're different questions, but they are interrelated, and sometimes one will have a little bit more bearing on a situation than perhaps another. Does a treatment or an operation or a procedure offer this patient a reasonable hope of benefit, without a serious danger of death, without anything excessive, excessive pain, excessive hardship, excessive burden? If a given treatment, in a given set of circumstances, does offer this patient that benefit without those excessives, then that treatment for that patient is an ordinary means. Okay? If, of course, it offers this particular patient no reasonable hope of benefit, or it's very problematic whether they will even make it out or make it through alive, or it involves some excessive burden or a combination of truly excessive things, then that particular procedure for that particular patient would be an extraordinary means. Okay? Therefore, we have to go case by case. Generally speaking, the Catholic rule is kind of easy. Ordinary means obligatory. Extraordinary means optional. Namely, we are bound to use all ordinary means to take care of our health, our life, and our bodily integrity. Whereas if it's an extraordinary means, that is truly the patient's choice. If someone wants to use it, he or she is free to use it. If they want to forego it, they are free to forego it. Now sometimes what confuses people is basically, how can the same procedure, how can the same operation be ordinary for one person and extraordinary for someone else? Doesn't that imply that we're really dealing from two sets of books or working both sides of the street? No. The nuance and the wisdom of this Catholic distinction, which is not a peculiar Catholic scruple, is basically we cannot carve in stone that one particular means or one particular operation is somehow ordinary for everyone and extraordinary for everyone else. We can't. We have to go case by case by case. Let's say a 16-year-old girl contracts pneumonia. She's kind of wiped out temporarily. In our society, they would administer antibiotics and sulfur drugs and treat that pneumonia very aggressively. Let's test it against our little rule. With the use of antibiotics and sulfur drugs, perhaps, for this otherwise healthy 16-year-old girl who has pneumonia, would it offer her a reasonable hope of benefit? It certainly would. Would it involve any serious danger of death? It certainly would not. Okay, 1 in a million perhaps has some kind of a bad reaction to a particular drug, but that should be clarified before its use. Does it involve any excessive pain? Quite the contrary, it will relieve the pain. Any excessive burden, I would think not. So that particular treatment of that particular patient would seem to me, and I believe all reasonable commentators, that would be an ordinary means, and therefore it would be morally obligatory. Our failure to apply an ordinary means would in fact be suicidal. So we call that an obligatory, that is an ordinary means, because it offers this particular patient, in her circumstances, a reasonable hope of benefit without danger of death and without anything excessive. Okay, same means, but a different case. Take an 81-year-old man who is suffering from different forms of cancer. There is the onset of renal failure, kidney trouble, and on comes pneumonia. Will they treat pneumonia in this second set of circumstances quite as aggressively as the first? And my guess is the answer to that is probably no. Now, I've loaded the case a little bit, because if he has kidney trouble, serious kidney trouble, you have to be careful what drugs they give to people who have kidney, or you will compound. If they use sulfur, they could hurt him. So does it offer a reasonable hope of benefit? Well, you'd have to flesh that out by the facts of the individual case. We can't say off the top of our head. Does it involve anything excessive? It might be. So generally speaking, if the facts of the second case be true, that might be for him an extraordinary means, in which case it would be optional, morally optional. That is, if somebody wanted and chose to employ this means, they would be free to. But if they chose not to, they would also be free not to use it. They could forego that. So that the very same means, and that's why we say that we can't speak in generalities, and we can't carve in stone or put some label on a particular device and say this is ordinary for everyone, this is extraordinary for everyone. We can't do that. We do presume it in a way in what we call minimal means, like food, water, bed rest, room temperature, personal hygiene. We figure that we owe these to human beings simply because of the fact that they are human beings. And as simple as that sounds, in our present society, that's what's being denied through legal moves to some human beings who, in the judgment of others, don't have the quality of life that some would like. But let's go back and see if we can't use some examples to explain somewhat the distinction of ordinary and extraordinary. I'd offer a little bit of a caution, particularly about older textbooks in this regard, and in particular, I suppose, especially certain Catholic textbooks in medical ethics, if they were printed in the early part of the 20th century or prior to World War II, because sometimes in older textbooks you'll come across statements that what is natural is ordinary and what is artificial is extraordinary. We cannot really say that anymore in our society. There are many things in a modern hospital, well, just about everything in a modern hospital is either in itself artificial or conveyed by an artificial means, obviously all surgery and so on. So they're not equivalent, they're not synonyms, and some of the books, well, if we put it in perspective, before there were great advances in surgery, very often, say prior to World War II, they didn't really know all the time what the real nature of the problem was. Well, to a large extent today, X-rays help solve that. In days of war, it was very difficult, sometimes impossible, to control hemorrhaging and infection. It's not completely solved, but it's much more under control today than it used to be. There was no accurate way sometimes to ascertain someone's capacity to withstand pain or withstand surgery. That can be managed today. In many cases, in many decades ago, there were no really safe anesthetics, and there are today. So if you picked up an older book, when it was written and in the context that it was written, almost any kind of surgery was about as dangerous as, say, letting nature take its course. We really can't say that in our society. I'm not speaking for what's available in Central Africa or at the North or South Pole. We're talking in terms of what is generally available within the, say, the United States or the North Atlantic community. So, for instance, what we call a major operation. There are many so-called major operations today in today's medicine where we do pay some attention, of course, to the expectation of success, to the degree of comfort in survival. But if we were to describe an appendectomy as major surgery, that would not make it extraordinary. I mean, does it offer someone a reasonable hope of benefit? It certainly does. As a matter of fact, if you don't do it, they're going to die. Without serious danger of death, that's what we're trying to prevent. Anything particularly excessive, not in that one. So that at least in our circumstances, in terms of what's available, I think we'd have to call an appendectomy a morally ordinary means of treatment in our country. And so it would be, I suppose, for many so-called major operations, that is, things that are done for a specific reason on an otherwise healthy patient. It could well be that there is some other condition not related with the primary focus of disease that would make it very risky for someone to undergo any type of surgery. Well, then that, of course, is a different case. Not because we're changing our principles, but because the circumstances have changed. It could be someone is just a poor surgical risk, their general health is so declined that any type of operation would be a big deal for them, or they would be a particularly poor risk for a particular surgery. On the other hand, where there are big operations where it really is only 50-50 that someone could come out alive, there are some major forms of heart surgery and major forms of brain surgery, which in our society, generally speaking, I think we would have to, at least initially, label as so-called extraordinary means. But again, I don't want to violate my own rule. We have to go back and judge each case by case. Does this particular operation, this treatment, this medication offer someone a reasonable hope of benefit without serious danger of death, without any excessive hardship, excessive burden, or anything excessive? We could change the focus, I suppose, to something like drugs. In general, there are many drugs currently in use in our society, which I think we would have to describe basically as ordinary. For instance, there are any number of our fellow citizens who are presently suffering from angina, and their regular intake of nitroglycerin tablets has kept them going and keeps them in pretty good shape. And if that's so, then it would seem to me, does that offer them a reasonable hope of benefit? It sure does. Without danger of death, it's preventing their death. Involve anything excessive? In general, no. If that's so in the case, in a given case, then that would be an ordinary means. The simple injection of adrenaline has saved all sorts of lives of people who are back up on their feet, which in modern medicine it's used. Now here, the only area where we would become very cautious, of course, would be sometimes in the context of the dying patient. Sometimes the administration of certain things which don't really offer a reasonable hope of benefit and may well involve some excessive pain or burden, or they might be, if you'll accept the phrase, and we've got to be careful with it, they might actually be useless. But remember, when we use the term useless, we are talking about a useless means. We are never talking about a useless person. There's no such thing as a useless person. So when we're talking up here, we're talking about an ordinary means, not ordinary persons, or an extraordinary means, not extraordinary persons. And so here, some procedures might well be useless in the sense that they offer no real benefit to a given patient in his or her circumstances, because in fact they're not going to make them better. And sometimes we do have to draw a line on whether or not we are really extending someone's life, or in the context of terminal illness, the question might be, are we prolonging the act of dying? Continued existence is normally thought to be a benefit, but nobody is obliged to prolong the act of dying, so to speak. So these terms, ordinary and extraordinary, again, to sum up, not in relation to medical science as it now is, but in relation to an individual patient in his or her factual, actual circumstances. And this terminology, although it's well accepted in Catholic circles, I don't want to give the wrong impression. You will find the same thing stated in the ethics of the American Medical Association in their current opinions, as those were published by the Judicial Council in 1981. It's well accepted in all things. What's really the basis? What's the basis for this distinction? Well, to some extent, the rock bottom basis, if we were to check it out, would be our basic understanding of the fifth commandment, but understood in both positive and negative terms. What do we mean fifth? Well, the fifth is kind of easy. Thou shalt not kill. Thou shalt not kill. Negatively, what does that mean? Negatively, in its quintessential essence, thou shalt not kill means thou shalt not directly take the life of an innocent or helpless person. That's a never. That's a moral absolute. We never directly, now each word counts in there, we never directly take the life of an innocent or a helpless person. If we say directly, we're not talking about accidents, we're not talking about vehicular homicide, unless you planned a vehicular homicide, but the direct lethal invasion of an innocent person's right to life, morally that's murder. We say innocent normally when we're talking about the unborn. We say helpless normally when we're talking about euthanasia, but in principle they're the same. The only real difference between abortion, direct abortion and direct euthanasia is age and size. The geography changes. You move from the womb to the ward, but the principle doesn't change. It's the same. So as a negative, and as a negative moral absolute, to which there are no exceptions, one can never directly take the life of an innocent or helpless person. That is precisely what we mean by murder. Okay. However, on the other side of that coin, there is as well a positive understanding of the Fifth Commandment. We have a positive obligation to take care of our life, our health, and our bodily integrity. The custodial care, the responsible stewardship, that useful dominion over human life, which we have on trust for a while. We have a positive obligation to take care of our life and our health. But that admits of reasoned and reasonable limits. That positive duty is fulfilled within reasonable and proportionate limits. We never said, and as a matter of fact, the Catholic Church never said, that you have to use all means all the time under all circumstances on all patients, whether they do them any good or not. We've never said that. In fact, I don't know of any Western religion that requires it. We have said never directly kill an innocent person. That we have said, but that's not murdering someone. But the positive side of that is to positively this is fulfilled within reasonable and proportionate limits. And that's why we have to go case by case by case to see whether or not something is an ordinary means or an extraordinary. And if it truly is extraordinary, morally extraordinary, then someone is free to use that or free not to use it. The non-usage of an extraordinary means is not euthanasia and should not be confused with euthanasia. As a matter of fact, in the ethical directives of Catholic health facilities, numbers 28 and 29 spell out in a lot shorter and fewer words what I have just been trying to explain. It says, for instance, euthanasia in all its forms is forbidden. The failure to supply ordinary means of preserving life is equivalent to euthanasia. However, neither the physician nor the patient is obliged to use extraordinary means. 29, it is not euthanasia to give a dying person sedatives or analgesics for the alleviation of pain when, or even though, they may deprive that patient of the use of reason or perhaps even shorten life. So it's a doubly nuanced thing. In the negative absolute, it's very clear and there are no exceptions. If in fact this is an innocent person who is helpless, no direct lethal assault on that person because morally that would be murder. On the other hand, in fulfilling affirmatively the positive obligation we have to take care of our life, our health, and our bodily integrity, we admit that that admits of reasonable and proportionate limits. We don't say you have to do it all the time, but that's truly the patient's choice. And the only way that can be determined is basically on a case-by-case situation. Okay? So it would be easier, and at times out of personal or collective frustration, some think, well, wouldn't it just be simpler if we drew up one long list and said this is ordinary for everybody, and this other list is extraordinary for everyone? It might sound simpler, but it simply would not honor reality or the complexity of it as we know it. Why? Because even who's ever listening or watching, some of what may be bothering you may not be bothering me, and vice versa. And that's why we have to go case by case by case. Everybody's health situation is a little bit different. In a capsule, sometimes a particular means that would get someone through a crisis and back up on their feet, obviously that would be an ordinary means for that person. But maybe that same means for someone else will not get them through the crisis. Maybe it will prolong the crisis or deepen the crisis. So the same means might be ordinary for one person and extraordinary for another. This terminology is very well received in conventional Judeo-Christian ethics, in specifically Catholic ethics, and in medical ethics generally and widely, well beyond the Catholic Church. However, in the society in which we now live, there are also efforts afoot to check and change our ethics in this regard. And one of the key things about the movement that is related to and part of euthanasia, one of the first things they have to do is to confuse the terminology, to get everybody jangled up, to get everybody convinced that no one else knows what they're doing, so that if we pass some funny, undesirable law, there'll be no problems. I take it as a little rule. I don't know what else to call it, so I call it Smith's rule. That makes it sound very, very American. The first thing you have to do in this area is remember that words are tactics. The very same people who brought about the legalization of direct abortion in our country are now working, and quite successfully, to bring about the legalization of mercy killing or euthanasia. And just as they succeeded in the first place, the first part of the battle was words. What do I mean words? I mean words are tactics. They really are tactics. And if you're talking about something that's really horrible, the best way you can make a presentation in public about something that's horrible is don't call it horrible. Call it something else. And I don't make it up. There was a famous, ferocious, pro-abortion editorial that appeared in a journal called California Medicine, volume 113, September 1970. You'll find it on page 68 of that journal. That was 3 years before our Supreme Court ruled. And they pointed out an awful lot of the traditional Western ethic hanging around our society. And under the traditional umbrella of traditional ethics, most people consider killing socially abhorrent. And then they make this statement: if the abortion movement is to succeed in this country, it is absolutely essential to separate the notion of abortion from the notion of killing. At first that sounds kind of odd, but it was crucial. It was crucial to the success of the abortion movement to separate the notion of killing from the notion of abortion. So the first thing that changed, before laws changed, words change. Little word pollution. What'd they do? Well, instead of saying killing the unborn, which is what abortion is, they say removing the product of conceptus, or terminating a pregnancy, or retroactive contraception. Call it anything, but never call it killing. Why? Because most people consider killing as socially abhorrent and as not desirable, and no one wants to be even stuck with that on their hands. But if you deflect their attention and distract their mind to call it something else, then it doesn't sound so horrible. Okay, here we are 10 years later. The same movement first appears in words. And the words in this area are, this time around, it will be crucial to separate the notion of killing, say, from the notion of euthanasia. And it's already begun. If you look at half the things you see on television, say, for instance, in the summer of 1985, there was no shortage of mercy killings, some highly publicized in the state of Florida, some in the state of Ohio, some actually legalized in the state of New Jersey. And watch how people refer to them, and watch how often the word killing disappears from the description mercy killing. And the people who will come on who are advocating change, they will talk about the right to die. And that sounds kind of attractive at first until you think about it. There is no right to die. A right is a claim we have on others to do something or refrain from doing something to us. We have no claim on death. That's backwards. Death has a claim on us. The fact that you and I were born guarantees we're going to die. But if someone comes along and says, well, we're going to talk up the right to die, if they're giving out rights, I'm liable to get online just as you are. I mean, this is the age of entitlement, so we get online if someone's giving out rights. But be careful, this is a bogus right. That's a trick. As a matter of fact, if you look up in Webster's dictionary, look up the word euthanasia. And in parentheses, you'll see mercy killing. But if you look up the second edition, the revised edition as of 1979, if you look up on page 631 of the new Webster's, you will see under euthanasia, 1, it says an easy, painless way of death. 2, an act or method of causing death painlessly advocated by some. You notice what happened? The word killing disappeared. It mysteriously disappeared. So it's important here to separate the notion of killing from the notion of euthanasia. It's also important to get into another form of word pollution. The notion of ordinary and extraordinary means is so well accepted that it too has to be put under a cloud and made part of a fog. And there is a present passion now in our own society to tone down and not explain nor employ the terms ordinary and extraordinary, and in that place talk about what some people call active and passive euthanasia. As if these were exactly the same terms, and they precisely are not exactly the same. So far, most people or most advocates claim that they're not talking about active euthanasia, although there really is no shortage of examples of active euthanasia. The horrible case in Florida where the fellow shot his wife who had Alzheimer's disease. The woman had just come back from lunch with her friends, and he shot her once in the head, stopped to load again, and do it again. We have no record that she asked for this. This is obviously an active case of active euthanasia. But so far, that's usually not where the trouble is or the tension is. The word active connotes doing something, commission, placing the deadly deed or placing the deadly dose. So far, many people say that they are opposed to that and are not talking about that. In fact, there exists in this country a group called the Hemlock Society, whose logo on their quarterly newsletter says that they favor voluntary, active euthanasia. But most say they're not there. The present problem is right here. The present problem most often is in what is called so-called passive euthanasia. And it really does present, pardon me, a terminological or a word problem. Why do I say that? Active connotes doing something. All right? What does the word passive connote? Passive connotes omission, withholding, withdrawing, omitting. Now, the problem with that term, passive euthanasia, is it's inherently ambiguous until we figure out or factor out just what is it that is being passively omitted or passively withheld or passively withdrawn. The omission, if you will, the omission of an extraordinary means, which is non-obligatory, which is the person's choice or the patient's choice, the omission of an extraordinary means, even the passive omission of an extraordinary means, that's not euthanasia, and it should not be so called, and it should not be confused. However, the passive omission of an ordinary means, that's something else, and that's something different. That would be the passive omission of an obligatory means, and that would be euthanasia, and it should be so called. So now in our many and several legislatures, state legislatures, ever since 1976, heavily since then there have been activities to pass so-called natural death acts or so-called living wills, or in some cases so-called durable power of attorney bills. One way or another, most of them buried in that legislation somewhere is the understanding of passive euthanasia. And since it is ambiguous, it's a little bit hard to pin down. Sometimes they say the withdrawal of medical maintenance treatment. Well, it depends what that means, doesn't it? If it means foregoing a fancy super-duper machine that you're not obliged to use, I agree, that's the patient's choice. You want to forego it, forego it. If you want to keep it going, that's your choice. Truly optional. But medical maintenance treatment, say someone is being presently maintained in a present condition merely on food and water, nutrition and hydration, as they say. Well, that's a horse of a different color. So until somebody explains in a given case what actually and factually is being passively omitted, I really can't come to terms with that expression, because I do believe that it is ambiguous on purpose. Our understanding of ordinary and extraordinary is so well accepted that the first way to jostle it and put it aside is to send up a smoke screen that sounds like it, but in practice will turn out to be something different. And in practice and in fact, this is something different. In large part, it sounds like it, but in fact, it is not the same. I think you will find always there is a trick hidden in the pro-euthanasia literature and the pro-euthanasia presentations. Normally, it goes along these lines. First of all, they'll give you one fact situation where supposedly we use all means, all the time, under all circumstances, on all people. We'll call that all in all. Nobody defends that position. Second, different scenario. Use all ordinary means. All ordinary means. Make extraordinary means optional. That's the conventional position. The conventional position of the Judeo-Christian ethic, the conventional position of the American Medical Association, and most of our state laws, with the exception of Arkansas. Thirdly, leave the patient a lethal dose, assisted suicide, or direct someone else to do so. Assisting a suicide. Now, what happens normally in public presentations is they're always giving you examples of number one, which no one defends, while pleading for the legalization of number three, which is very different. Just as 3 differs from 2 and 2 differs from 1, and they're all different situations from each other. But they're counting on confusion by confusing the terminology. And if I'm not mistaken, the soft underbelly of the euthanasia movement in this country will be the introduction or the so-called decriminalization of assisted suicide. What do I mean? In most jurisdictions, suicide is not a crime. Or if it is a crime, it has no penalty. Obviously, if someone succeeds in that effort, the question's quite moot. If someone fails to succeed in a suicidal effort, most of us are convinced that person needs help, not a jail cell. They need medical help, they need counseling. However, in many jurisdictions in this country, there is a statute, that is, there is a law against assisting a suicide. And that presently is what they are trying to dismantle through the ambiguous use of the termination of, or the omission of, ordinary means, which they are cloaking as a patient's right. A patient's right to forego any means. Well, I can't say that without distinction. A patient's right to forego extraordinary means, I agree, and that should be on it, and it will be on it, and I know it's on it in Catholic institutions and in other institutions. But does the patient have a right to omit ordinary means? Now that's a call for suicide, and those who help or assist in it. Now in most jurisdictions that's illegal. And as you read some of the living will legislation, you get to the back of the bill and you'll find after paragraph 9 or 10 or whatever, it says this is not suicide, and for criminal purposes this is not suicide, and for insurance purposes this is not suicide. Like the old business, after they tell you 9 times, this is not a witch hunt, this is not a witch hunt, this is not a witch hunt, eventually you're pretty sure of one thing, it's a witch hunt. And that's what's going on here. This is not a suicide, this is not a suicide. Well, that draws our attention to something to which there is no criminal penalty, and it draws our attention away from where it is, namely that assisting in a suicide. Because the passive omission of an ordinary means is in fact a form of suicide. This unfortunately was the nub of a case that came up and stayed in court, different levels in court in the state of New Jersey for over 3 years. The so-called Claire Conroy case. Miss Conroy was an 84-year-old lady who was suffering basically no terminal illness, but she was suffering what they call organic brain syndrome, which is senility, and some other dysfunctions. A nephew appeared after one of her hospitalizations, and requested that a nasal gastric tube, which was presently feeding her and nourishing her and hydrating her, be removed. And they went to the first jurisdiction of a court, which said no. That was appealed to a court that said yes, and that was finally appealed to the New Jersey Supreme Court, which handed down a decision on the 17th of January in 1985. Unfortunately, on page 53 of that decision on the Conroy case, the Supreme Court of the state of New Jersey said that they saw no difference between actively causing death and passively allowing someone to die. They saw no difference between actively bringing about death and passively allowing someone to die. There is a difference. And 3 times, some cases, there may be some hairs to split, but when someone's life is at stake, we should be willing to split a few hairs. Besides that, they say over and over, in fact, they say on 3 separate occasions, that a patient has a right to forego any medical treatment. Well, we say we have to look case by case by case to figure out whether something is ordinary or extraordinary. But generally, we do presume that food, water, bed rest, room temperature, and hygiene, we should offer these to all human beings simply because they're human beings. Now, we're not talking necessarily, if the case had been that this particular nasal gastric tube was proving so uncomfortable and causing Miss Conroy all sorts of pain and hardship, and that it was excessive, that would be arguable. But that wasn't the argument. The argument was basically a third party simply deciding to remove or withdraw what we would call ordinary food and nourishment. And that case, if it becomes a precedent, and if it starts to set precedents in other states in this country, will cause great difficulty, profound difficulty, because what's happening basically there is the omission of an ordinary means. Sometimes the logical nexus or the connection or the sequence of something, when it's a commission of doing something, it's much easier to see. But an omission is not so easy to see. But there are some omissions of basic maintenance that are so fundamental that their omission is lethal. For instance, we talk about room temperature. Well, if you come up to the northern part of the country in the middle of February, you go into a hospital. If you can open the window, many modern windows don't seem to be openable, but if you open the window and then the room goes down to about 32 degrees and some elderly gentleman is suffering from pneumonia, you could say in a sense, I didn't touch him. I didn't give him a needle. I didn't hit him with anything. I didn't commit a commission. But that's no mere omission, is it? The omission of room temperature, in that case, would be fatal. So it would be with the omission of food and water and basic hygiene. It could cause complications, if not kill, which is less likely. But that's why it is very important in this area that when some begin to confuse the terminology, hit the public with hardship cases that are very often in the eye of the beholder, and then start crying out for necessary legislation which is unnecessary, that I offer the caution. We have to do a much better job of explaining to our own people that there really is nothing to apologize for here. But we have to know what we're talking about. We have to encourage health professionals who do know what they're talking about to distinguish, as they know we must distinguish, between easy cases and hard cases and hardship cases. But sometimes the impression is given that doctors and nurses in particular, health personnel in general, are running around forcing people to use procedures that they do not want. That's really not true. It's not true. The old distinction is a current distinction, and it's worthy of observance. Yes, we should offer all ordinary means to everybody. But extraordinary means, they are the patient's choice. They want to use them, use them. You want to forego them? Forego them. That's what optional means, and that's what it is, and that should be honored. And there's nothing to apologize for in that regard. We have lived with that distinction and implemented it on a case-by-case basis. Such decisions are made every day in every major hospital, in every major city in this country, and in smaller places day by day. Granted, every now and then we come across a very hard case. Well, in that case, people seek another opinion. They do what any prudent person would do. You seek more advice, more input, to make sure that the principle that we are clear about actually applies here and that it applies properly. If so, we go with it, as we should, because that's quite proper. But to give the impression that doctors and nurses are running around all confused and somebody's going to draw up a law somewhere that's going to solve all these hard cases, that can't be done. We cannot legislate compassion. All we can do is legalize killing. And unfortunately, that's already been done in the first few months of life. Sometimes you bring up cases and they are hard, so-called hard cases, and they involve compassion. Has compassion been legislated? Not at all. Not an ounce. All that's been legalized is killing. And once you legalize killing for any reason, then of course it's available for every other reason. And that's part of the problem. And it's the same principle basically. Whether it is the unborn in the first 9 months of life, or the newborn who don't breathe too well, or whose quality of life in the judgment of someone else is not optimum, or what have you, or whether it's the long-born who are 90 or less, but who are chronically ill. It's all the same principle. And we make that a little bit of a rule. Whether it's the newborn, or the unborn, or the long-born, it's always the same principle. Never directly attack an innocent or a helpless person, because morally that is murder. It's a direct lethal assault. Positively we make a distinction that we take care of life and health and bodily integrity by the offering of ordinary means to everybody, but extraordinary are the patient's choice. It's the same principle whether it's at the beginning of life or at the end of life. And since that principle was knocked out of our civil law at the beginning of life, it's inevitable that someone was going to bring it around and tack it on to the other. That's one of the things about principles. Once you break a principle to advance perhaps what someone thinks is one desirable social reason or multiple social reasons, once you break the principle, you can't call that principle back to prevent what you didn't desire or what you now consider undesirable social reasons or social causes. That's the trouble with principles. And once you break the principle, it's not a principle anymore. It's a porous piece of cheese through which you can sometimes drive a truck, or in this context, you could probably drive a hearse. So we want to try and refine somewhat good doctors and good lawyers, for that matter, and good health professionals are aware. And they are aware that this is part of their commitment to their own medical ethics and their own oath of their profession. The first rule of all medical ethics is what they call primum non nocere. First, do no harm. First, do no harm. And that's perfectly compatible with the principle we were trying to spell out. We do offer all ordinary means because they're obligatory. Extraordinary means are truly optional. And that term, which goes on a case-by-case basis, it's applied and modulated by factual, actual circumstances, has been in the possession of the healthcare community and moralists or ethicists for hundreds of years, highly refined by our late Pope Pius XII, and as recently as the 5th of May in 1980, authorities in the Vatican became so concerned about certain movements in the English-speaking world and in elements of the Catholic Church in the English-speaking world that they issued a decree on declaration on euthanasia on the 5th of May 1980, not because any principle has changed, but because so much confusion was being generated by certain media-minded cases that they thought it was not only timely, but necessary. And that's the way it is very often in morality. It's not that we have to invent a new principle or discover a new principle. Most often in moral matters, we need to be reminded, not invented. We have to remember perhaps what we have forgotten. And what's most often forgotten in our society is that human life is a gift that we have on trust for a while. And then we go back to God. And since we are trustees of our own life, not owners, trustees, and since we have at best custodial and useful dominion over our life and the same kind of custodial trustee relationship with the lives of others, we don't throw things away, we don't destroy life, we have no right to, ours or anyone else's. But in that custodial trust, we do observe this long, time-honored, meaningful distinction between ordinary and extraordinary means. That what really offers someone a reasonable hope of benefit without serious danger of death, without excessive pain, excessive hardship, excessive burden, with that little moral criterion, we are able to distinguish, admittedly on a case-by-case basis, of what kind of moral responsibility is involved, because if we follow that, we will honor that fundamental thing. We will honor that trust of human life, which is put in our hands for ourselves. And maybe we should say that. The only one really who can and should decide what is or is not an ordinary and extraordinary means for you is you, and me for me. I don't decide for you. I outline the parameters within which the Church offers a certain perimeters. But since we say it's case by case, it is case by case. I decide for me, you decide for you. But be very careful, in fact be cautious, of those types and elements and allegedly libertarian units in our society who are saying all of a sudden that someone's going to pass a law so that there'll be no more hard cases anymore. That's nonsense. There'll always be a few of them, and there we just become a little bit more cautious. We rely even more on a fuller discussion, a fuller consultation. We rely more on those who have the experience and the wisdom to actually know what they're talking about. And if it takes a little longer, because it's complicated, then it takes a little longer. Where human life is concerned, we really shouldn't be interested in shortcuts. We have already short-circuited those of us who are fewer than 9 months old. And if we ourselves get confused, we'll be part of the confusion on those, all of us, who are over 9 months old. But always that basic principle. Where there is no cure, we still provide human care. And in all circumstances, we always offer minimal means. Food, water, bed rest, room temperature, hygiene. That's no different from the 25th chapter of St. Matthew, where Jesus said himself, "Whatever you do to the least of my brothers, you do to me. If you so much as give a cup of water to one of the least of my brothers." Now, one of the least of our brothers may be an 85-year-old lady who has organic brain syndrome, or maybe a newborn baby who doesn't breathe too well. If we're ever in doubt, or we're confused by terminology, simply remember the gospel. Whatever you do for the least of those brothers, you do to Jesus, and alternatively, whatever we fail to do for the least of our brothers and sisters, we fail to do to Jesus Christ.